Chapter 6 Judiciary Introduction. Many times courts are seen only as arbitrators in disputes between individuals or private parties, but judiciary performs some political functions also. Judiciary is an important organ of the government. The Supreme Court of India is in fact one of the very powerful courts in the world. Right from 1950, the judiciary has played an important role in interpreting and in protecting the Constitution. In this chapter, you will study the role and importance of the judiciary. In the chapter on fundamental rights, you have already read that the judiciary is very important for protecting our rights. After studying this chapter, you would be able to understand the meaning of independence of judiciary, the role of Indian judiciary in protecting our rights, the role of the judiciary in interpreting the Constitution, and the relationship between judiciary and the Parliament of India. Why do we need an independent judiciary? In any society, disputes are bound to arise between individuals, between groups, and between individuals or groups and government. All such disputes must be settled by an independent body in accordance with the principle of rule of law. This idea of rule of law implies that all individuals, rich and poor, men or women, forward or backward caste, are subjected to the same law. The principal role of judiciary is to protect rule of law and ensure supremacy of law. It safeguards rights of the individual, settles disputes in accordance with the law, and ensures that democracy does not give way to individual or group dictatorship. In order to be able to do all this, it is necessary that the judiciary is independent on any political pressures. What is meant by an independent judiciary? How is this independence ensured? Independence of judiciary. Simply stated, independence of judiciary means that the organs of the government, like the executive and the legislature, must not restrain the functioning of the judiciary in such a way that it is unable to do justice. The other organs of the government should not interfere with the decision of the judiciary. Judges must be able to perform their functions without fear or favor. Independence of the judiciary does not imply arbitrariness or absence of accountability. Judiciary is a part of the democratic political structure of the country. It is therefore accountable to the Constitution of the democratic traditions and to the people of the country. How can the independence of judiciary be provided and protected? The Indian Constitution has ensured the independence of the judiciary through a number of measures. The legislature is not involved in the process of appointment of judges. Thus, it was believed that party politics would not play a role in the process of appointments. In order to be appointed as a judge, a person must have experience as a lawyer and or must be well versed in law. Political opinions of the person or his or her political loyalty should not be the criteria for appointments of judiciary. The judges have a fixed tenure. They hold office till reaching the age of retirement. Only in exceptional cases judges may be removed, but otherwise they have security of tenure. Security of tenure ensures that judges could function without fear or favor. The Constitution prescribes a very difficult procedure for removal of judges. The Constitution makers believe that a difficult procedure of removal would provide security to office to the members of the judiciary. The judiciary is not financially dependent on either of the executive or legislature. The Constitution provides that the salaries and allowances of the judges are not subjected to the approval of the legislature. The actions and decisions of the judges are immune from personal criticisms. The judiciary has the power to penalize those who are found guilty of contempt of court. This authority of the court is seen as an effective protection to the judges from unfair criticism. Parliament cannot discuss the conduct of the judges except when the proceeding to remove a judge is being carried out. This gives the judiciary independence to adjudicate without fear of being criticized. Appointment of judges. The appointment of judges have never been free from political controversy. It is part of the political process. It makes a difference who serves in the Supreme Court and High Court, a difference in how the Constitution is interpreted. The political philosophy of the judges, their views about active and assertive judiciary or controlled and committed judiciary have an impact on the fate of the legislations enacted. Council of Ministers, Governors, and Chief Ministers and Chief Justice of India all influence the process of judicial appointment. As far as appointment of the Chief Justice is concerned, over the years a convention had developed whereby senior most judge of the Supreme Court was appointed as the Chief Justice of India. This was appointed as CGI, superseding three senior judges. Again, Justice M. H. Beck was appointed superseding Justice H. R. Khanna in 1975. The other judges of the Supreme Court and the High Court are appointed by the President after consulting the CGI. This is in effect meant that the final decisions in the matters of appointment rested with the Council of Ministers. What then was the status of the consultation with the Chief Justice? This matter came up before the Supreme Court again and again began between 1982 and 1998. Initially, the court felt that it took the view that the opinion of the Chief Justice must be followed by the President. Finally, the Supreme Court has come up with a novel procedure. It has names of persons to be appointed in consultation with the senior most judges of the court. Thus, the Supreme Court has established a principle of collegiality in making recommendations for appointments. At moment, therefore, in matters of appointment, the decision of the group of senior judges of the Supreme Court carries greater weight. Thus, in matters of appointment to the judiciary, the Supreme Court and the Council of Ministers play an important role. Removal of judges. The removal of judges of the Supreme Court and the High Court is also extremely difficult. A judge of the Supreme Court or High Court can be removed only on the ground of proven misbehavior or incapacity. A motion containing the charges against the judge must be approved by the special majority in both houses of the Parliament. Do you remember what special majority means? We have studied this in the chapter on elections. It is clear that from this procedure that removal of a judge is a very difficult procedure, and unless there is a general consensus among members of the Parliament, a judge cannot be removed. It should also be noted that while in making appointments, the executive plays a crucial role. The legislature has the powers of removal. This has ensured both balance of power and independence of the judiciary. So far, only one case of removal of a judge of the Supreme Court came up for consideration before Parliament. In that case, through the motion of the got two-thirds majority, it did not have the support of the majority of the total strength of the House, and therefore the judge was not removed. Unsuccessful attempt to remove a judge. In 1991, the first ever motion to remove a Supreme Justice was signed by 108 members of Parliament. Justice V. Ramaswamy, during his tenure as the Chief Justice of the Punjab and Haryana High Court, was accused of misappropriating funds. In 1992, a year after Parliament has started the removal proceedings, a high-profile inquiry commissioned consisting of judges of the Supreme Court found Justice V. Ramaswamy guilty of willful and gross misuses of office and moral turpitude by using public funds for private purposes and reckless disregard of the statutory rules while serving as the Chief Justice of the Punjab and Haryana High Court. Despite the strong indictment, Ramaswamy survived the parliamentary motion recommending removal. The motion recommending his removal got the required two-thirds majority among the members who were present and voting, but the Congress party abstained from voting in the House. Therefore, the motion could not get the support of one half of the total strength of the House. Structure of the judiciary. The Constitution of India provides for a single integrated judicial system. This means that unlike some other federal countries of the world, India does not have separate state courts. The structure of the judiciary in India is pyramidal, with the Supreme Court at the top, high courts below them, and district and subordinate courts at the lowest level. The lower courts function under the direct superintendent of the higher courts. Jurisdiction of Supreme Court. The Supreme Court of India is one of the most powerful courts anywhere in the world. However, it functions within the limitations imposed by the Constitution. The functions and responsibilities of the Supreme Court are defined by the Constitution. The Supreme Court has specific jurisdiction or scope of powers. Original jurisdiction. Original jurisdiction means cases that can be directly considered by the Supreme Court without going to the lower courts before that. From the diagram above, you will notice that cases involving federal relations go directly to the Supreme Court. The final jurisdiction of the Supreme Court establishes it as an umpire in all disputes regarding federal matters. In any federal country, legal disputes are bound to arise between the Union and the states and among the states themselves. The power to resolve such cases is entrusted to the Supreme Court of India. It is called original jurisdiction because the Supreme Court alone has the power to deal with such cases. Neither the High Court nor the lower courts can deal with such cases. In this capacity, the Supreme Court not just settles disputes but also interprets the powers of union and state government as laid down in the Constitution. Writ jurisdiction. As you have already studied in the chapter on fundamental rights, on any individual whose fundamental rights has been violated can directly move the Supreme Court for remedy. The Supreme Court can give special orders in the form of writs. The High Courts can also issue writs, but the persons whose rights are violated have the choice of either approaching the High Court or approaching the Supreme Court directly. Through such writs, the court can give orders to the executive to act or not to act in a particular way. Appellate jurisdiction. The Supreme Court is the highest court of appeal. A person can appeal to the Supreme Court against the decisions of the High Court. However, High Court must certify that the case is fit for appeal. That is to say that it involves a serious matter of interpretation of law or constitution. In addition, in criminal cases, if the lower court has sentenced a person to death, then an appeal can be made to the High Court or the Supreme Court. Of course, the Supreme Court holds the powers to decide whether to admit appeals, even when appeal is not allowed by the High Court. Appellate jurisdiction means that the Supreme Court will reconsider the case and legal issues involved in it. If the court thinks that the law of the Constitution has a different meaning from what the lower courts understood, then the Supreme Court will change the ruling and along with that also gives interpretation of the provision involved. The High Courts too have appellate jurisdiction over the decisions given by courts below them. Advisory jurisdiction. In addition to the original and appellate jurisdiction, the Supreme Court of India possesses advisory jurisdiction also. This means that the President of India can refer any matter that is of public importance or that which involves interpretation of the Constitution to Supreme Court for advice. However, the Supreme Court is not bound to give advice on such matters and the President is not bound to accept such an advice. What then is the utility of the advisory powers of the Supreme Court? The utility is twofold. In the first place, it allows the government to seek legal opinion on a matter of importance before taking action on it. This may prevent unnecessary litigations later. Secondly, in the light of the advice of the Supreme Court, the government can make suitable changes in its actions or legislations. Article 137 says the Supreme Court shall have power to review any judgment pronounced or order made by it. Article 144. All authorities, civil and judicial, in the territory of India shall act in aid of the Supreme Court. Judicial activism. Have you heard of the term judicial activism or public interest litigation? Both these terms are often used in the discussions about judiciary in recent times. Many people think that these two things have revolutionized the functioning of judiciary and made it more people-friendly. The chief instrument through which the judicial activism has flourished in India is public interest litigation, PIL, or social action litigation, SAL. What is PIL or SAL? How and when did it emerge? In normal course of law, an individual can approach the courts only if he or she has been personally aggrieved. That is to say, a person whose rights have been violated or who is involved in a dispute could move to court of law. This concept underwent a change around 1979. In 1979, the court set the trend when it decided to hear where the case was filed not by the aggrieved persons but by others on their behalf. As this case involved a consideration of an issue of public interest, it and such other cases came to be known as public interest litigations. Around the same time, the Supreme Court also took up the case about rights of prisoners. This opened the gates for a large number of cases where public spirited citizens and voluntary organizations sought judicial intervention for protection of existing rights, betterment of life conditions of the poor, protection of the environment, and many other issues in the interest of the public. PIL has become the most important vehicle of judicial activism. Judiciary, which is an institution that traditionally confined to responding to cases brought before it, began considering many cases merely on the basis of the newspaper reports and postal complaints received by the court. Therefore, the term judicial activism became the more popular description of the role of judiciary. Some early PILs. In 1979, newspapers published reports about under trials. There were many prisoners in Bihar who had spent long years in jail, longer than they should have been spent if they had been punished for the offenses for which they were arrested. This report prompted an advocate to file a petition. The Supreme Court heard this case. It became famous as one of the early public interest litigations. This was the Husainara Khatun versus Bihar case. In 1980, a prison inmate of the Tihar jail managed to send a scribbled piece of paper to Justice Krishna Iyer of the Supreme Court, narrating physical torture of the prisoners. The judge got it converted into a petition, though later on the court abandoned the practice of considering letters. This case was known as Sunil Batra versus the Delhi administration, also became one of the pioneers of PIL. Through the PIL, the court has expanded the idea of rights. Clean air, unpolluted water, decent living are rights of the entire society. Therefore, it was felt by the courts of the individuals as parts of the society must have the right to seek justice wherever such rights were violated. Secondly, through PIL and judicial activism of the post 1980 period, the judiciary has also shown readiness to take into consideration of those sections who cannot easily approach the courts. For this purpose, the judiciary allowed public spirited citizens, social organizations, and lawyers to file petitions on behalf of the needy and the deprived. It must be remembered that the problems of the poor are qualitatively different from those which have hitherto occupied the attention of the court, and they need a different kind of judicial approach. If we blindly follow the adversarial procedure in their case, they would never be able to enforce their fundamental rights. Justice Bhagwati in Bandhoa Mukti Morcha versus Union of India 1984. Judicial activism has had manifold impact on the political system. It has democratized the judicial system by not giving just to individuals but also groups access to the courts. It has forced executive accountability. It has also made an attempt to make the electoral system much more free and fair. The court asked candidates in contesting elections to file affidavits indicating their assets and income along with educational qualifications so that the people could elect their representatives based on the accurate knowledge. There is, however, a negative side to the large number of PILs and the idea of proactive judiciary. In the first place, it has overburdened the courts. Secondly, judicial activism has blurred the line of distinction between the executive and legislature on the one hand and judiciary on the other. The court has been involved in resolving questions which belong to the executive. Thus, for instance, reducing air or soil or sound pollution or investigating cases of corruption or bringing about electoral reform is not exactly the duty of the judiciary. They are matters to be handled by the administration under the supervision of the legislatures. Therefore, some people feel that judicial activism has made the balance among the three organs of government very delicate. Democratic government is based on each organ of government respecting the powers and jurisdiction of the others. Judicial activism may be creating strains of this democratic principle. You are the judge. A group of citizens from a city have approached a court through a PIL asking for an order to the city municipal authorities to improve or to remove slums and beautify the city in order to attract investors to the city. They argue that this is in the public interest. The residents of the slum localities have responded by saying that this will encroach on their right of life. They argue that the right to life is more central to public interest than the right to a clean city. Imagine that you are the judge. Write a judgment deciding if the PIL involves public interest. Judiciary and rights. We have already seen that the judiciary is entrusted with the task of protecting rights and individuals. The Constitution provides two ways in which the Supreme Court can remedy the violation of rights. First, it can restore the fundamental rights by issuing writs of habeas corpus, mandamus, etc. Article 32. The High Courts also have the power to issue such writs. Secondly, the Supreme Court can declare the concerned law as unconstitutional and therefore non operational. Together, these two provisions of the Constitution establish the Supreme Court as the protector of the fundamental rights of the citizen on the one hand and interpreter of Constitution on the other. The second of the two ways mentioned between above involves judicial review. Perhaps the most important power of the Supreme Court is the power of judicial review. Judicial review means the power of the Supreme Court to examine the constitutionality of any law if the court arrives at the conclusion that the law is inconsistent with the provisions of the Constitution. Such a law is declared as unconstitutional and inapplicable. The term judicial review is nowhere mentioned in the Constitution. However, the fact that India has a written constitution and the Supreme Court can strike a law that goes against fundamental rights implicitly gives the Supreme Court the power to judicial review. Besides, as we saw in the section of jurisdiction of the Supreme Court, in the case of federal relations too, the Supreme Court can use the review powers if a law is inconsistent with the distribution of powers laid down by the Constitution. Suppose the central government makes a law which, according to some states, concerns a subject from the state list. Then the states can go to the Supreme Court, and if the court agrees with them, it would declare that the law is unconstitutional. In this sense, the review power of the Supreme Court includes power to review legislations on the ground that they violate fundamental rights or on the ground that they violate the federal distribution of powers. The review power extends to the laws passed by state legislatures also. Together, the writ powers and the review power of the court makes the judiciary very powerful. In particular, the review power means the judicial can interpret the Constitution and the laws passed by the legislature. Many people think that this feature enables the judiciary to protect the Constitution effectively and also to protect the rights of citizens. The practice of entertaining PILs have further added to the powers of judiciary in protecting rights of citizens. Did you know that the practice of public interest litigation is now becoming more and more acceptable in many other countries? While many courts across the world, particularly in South Asia and Africa, practice some form of judicial activism comparable to the Indian judiciary, the Constitution of South Africa has incorporated public interest litigation in its Bills of Rights. Thus, in South Africa, it is fundamental right of the citizen to bring up before the Constitutional Court cases of violation and other persons' rights. Do you remember that in the chapter on rights we mentioned the right against exploitation? This right prohibits forced labor, trade in human flesh, and prohibits employment of children in hazardous jobs. But the question is, how could those whose rights were violated approach the court? PIL and judicial activism made it possible for courts to consider these violations. Thus, the court considered a whole set of cases: the blinding of the jail inmates by the police, inhuman working conditions in the stone quarries, sexual exploitation of children, and so on. This trend has made rights really meaningful for the poor and disadvantaged sections. Judiciary and the Parliament. Apart from taking a very active stand on the matter of rights, the court has been active in seeking to prevent subversion of the constitution through political practice. Thus, areas that were considered beyond the scope of judicial review, such as powers of the president and the governor, were brought under the purview of the courts. There are many other instances in which the Supreme Court actively involved itself in the administration of justice by giving directions to executive agencies. Thus, it gave directions to the CBI to initiate investigations against politicians and bureaucrats in the Hawala case, the Naris Simha Rao case, illegal allotment of petrol pumps case. You may have heard about some of these cases. Many of these instances are the products of the judicial activism. The Indian constitution is based on a delicate principle of limited separation of powers and checks and balances. This means that each organ of the government has a clear area of functioning. Thus, the parliament is supreme in making laws and amending the constitution. The executive is supreme in implementing them, while the judiciary is supreme in settling disputes and deciding whether the laws that have been made are in accordance with the provisions of the constitution. Despite such clear cut decisions or division of power, the conflict between the parliament and the judiciary and the executive and remained a recurrent theme in Indian politics. We have already mentioned the differences that emerge between the parliament and judiciary over right to property and the parliament's power to amend the constitution. Let us recapitulate that briefly. Immediately after the implementation of the constitution began, a controversy arose over the parliament's power to restrict right to property. The parliament wanted to put some restrictions on the right to hold property so that land reforms could be implemented. The court held the parliament cannot thus restrict fundamental rights. The parliament then tried to amend the constitution, but the court said that even through an amendment, a fundamental right cannot be abridged. The following issues were at the center of the controversy between the parliament and the judiciary. What is the scope of right to property? What is the scope of the parliament's power to curtail, abridge, or abrogate fundamental rights? What is the scope of parliament's power to amend the constitution? Can the parliament make laws that abridge fundamental rights while enforcing directive principles? While there can be no two opinions on the need of the maintenance of the judicial independence, it is also said to be necessary to keep in view one important principle. The doctrine of independence is not to be raised to the level of a dogma so as to enable the judiciary to function as a kind of super legislature or super executive. The judiciary is there to interpret the constitution or the adjudicate upon the rights. Alahadi Krishnaswamy Iyer in 1949. During the period 1967 and 1973, this controversy became very serious. Apart from land reform laws, enforcing preventive detention, laws governing reservation and jobs, regulations acquiring private property for public purposes, and laws deciding the compensation for such acquisition of private property were some instances of the conflict between the legislature and the judiciary. In 1973, the Supreme Court gave a decision that has become very important in regulating the relations between the Parliament and the judiciary since then. This case is famous as the case of Nanda Bharati case. In this case, the court ruled that there is a basic structure of the constitution and nobody, even the parliament, can violate the basic structure. The court did two more things. First, it said that right to property was not part of basic structure and therefore could be suitably abridged. Secondly, the court reserved itself the right to decide whether various matters are part of the basic structure of the constitution. This case is perhaps the best example of how judiciary uses its power to interpret the constitution. This ruling has changed the nature of conflicts between the legislature and the judiciary. As we studied earlier, the right to property was taken away from the list of fundamental rights in 1979, and this also helped in changing the nature of the relationship between these two organs of government. Some issues will remain a point of contention between the two. Even the judiciary intervene Can the judiciary intervene in and regulate the functioning of the legislatures? In the parliamentary system, the legislature has the power to govern itself and regulate the behavior of its members. Thus, the legislature can punish a person who the legislature holds guilty of breaching privileges in the legislature. Can a person who is held guilty for breach of parliamentary privileges seek protection of the courts? Can a member of the legislature against whom the legislature has taken disciplinary action get protection from the court? These issues are unresolved and are matters of potential conflict between the two. Similarly, the Constitution provides the conduct of judges cannot be discussed in the Parliament. There have been several instances where the Parliament and the state legislatures have cast aspersions on the functioning of the judiciary. Similarly, the judiciary too has criticized the legislatures and issued instructions to the legislatures about the conduct of legislative business. The legislatures see this as violating the principle of parliamentary sovereignty. These issues indicate how delicate the balance between any two organs of the government is and how important it is for each organ of the government in a democracy to respect the authorities of others. Conclusion. In this chapter, we have studied the role of the judiciary in our democratic structure. In spite of the tensions that arose from time to time between the judiciary and the executive and the legislature, the prestige of the judiciary has increased considerably. At the same time, there are many more expectations from the judiciary. Ordinary citizens also wonder how it is possible for many people to get easy acquittals and how witnesses change their testimonies to suit the wealthy and the mighty. There are some issues about which our judiciary is concerned too. We have seen in this chapter that judiciary in India is a really powerful institution. This power has generated much awe and many hopes from it. Judiciary and in India is also known for its independence. Through various decisions, the judiciary has given new interpretations to the constitution and protected the rights of citizens. As we saw in this chapter, democracy hinges on the delicate balance of power between the judiciary and the parliament, and both institutions have to function within the limitations set by the institution.